All right. So it's an app. Okay, just take on
I stopped at 18.
What's that?
I stopped at 18.
Give you an extra 15 minutes.
I know, we can't. We need to make sure it's.
Oh, no, we put yours in. In the middle. That's nothing to do.
That is not the ways we've done it our chair.
Oh.
Just that.
Anyone that's wishing to speak on the case, you haven't signed in, please do so, so that you know, take your case number here for.
There is. I understand. So what do you say we should bring on?
You know, that, in those days, I just walk in there.
You either.
We have the auto lady.
My grandmother.
You too.
Great. Here's like.
Right. Right.
Yeah. I go there.
Look, let's get started. All right. So- All right, I'd like to call the Ohio Elections Commission December 2nd, 2021 meeting to order. Roll call, please.
Ms. Kaufman?
Here.
Mr. Brower? Here. Ms. Cunningham?
Present.
Mr. Norman? Here. Vice Chair Beatty?
Here.
Chair Bright? Here. Ms. Tavares is currently not present.
I'm expecting her to.
I haven't seen anything that says she wasn't
That's
present,
fine.
but it's possible that she is not.
All right, let's find out.
That's interesting.
All right, first item on the agenda this morning would be approval of the regular meeting minutes of November the 18th, 2021. Everyone should have received a copy of those minutes. Are there any additions or corrections to the minutes?
Phil,
Commissioner Cunningham?
Phil forgot to update the first two items or
The agenda.
on the agenda in
Yeah.
terms of meeting date and
Yeah, okay.
That's right.
and minutes, but they should reflect December 2nd and it should reflect November 18th. So,
All right.
Well, you had them out early, so that's good.
All right.
Move to approve.
Second.
All right, further discussion, all in favor of the motion to approve the regular meeting minutes of November 18th, 2021, signify by saying aye.
Aye.
Opposed, same sign, motion carries. All right, moving into the preliminary reviews, the first case on the docket this morning is case 2021G-014, Barr versus Council Leadership Fund PAC et al.
Mr. Chair, members of the commission, this is a complaint filed against two separate parties, Council Leadership Fund PAC and Anthony Brackatelli. The complaint alleges a couple of different things. One, either that the respondent PAC simply failed to include the necessary independent expenditures disclaimer on its materials, or that there was coordination between the two respondents as they conducted their activities in the most recent election. Originally, we had Mr. McTighe's office as counsel for the complainant, but they withdrew yesterday. I see Pat Quinn here, so I see Mr. Quinn from Brewer Firm must be now representing Ms. Mauer.
That's right.
And Zach West is here on behalf of the Council Leadership Fund. You have before you a response that I received this morning by email. It also came in overnight from Anthony Brackatelli, which is there. Get a copy of that.
I've not seen that.
Chris, I dumped all the rest of it.
Yes.
The other copy for me. Did you get one too, Zach?
Possibly I'd like to see.
Yeah, if you give me back one of them when I did it. I guess it was good. I printed out a couple extra. But anyway, we could hear from the council and the commission, so.
Would be fine. Mr. Quinn, are you prepared to proceed?
I am, just for a few minutes, Mr. Chair. I
Go
will
ahead.
leave to the commission's discretion to decide whether my presence and movements with the tide is a good thing or a bad thing. What I would say on behalf of the complainant very briefly is that there's really no real dispute here that there are violations. The only question is which set of violations we're talking about. If the materials are, as the complaint alleges in Maine, in-kind contributions, that leads down a path of excessive contributions, incomplete, inaccurate financial disclosures, etc. If they're independent expenditures, we go down the path of the incorrect, inaccurate disclaimer. So what I would suggest, ladies and gentlemen, is that which path we go down here, it turns really on a factual issue, which is whether or not these materials, these four materials referenced in the complaint, were made with consent or coordination or cooperation or consultation between the PAC and the benefited candidate. In terms of what the commission has before you to resolve or to consider that factual issue, you have on the complainant side, you have her sworn affidavit and you have the materials themselves. I know you've all had a chance to look at them, but just very briefly to kind of summarize as you go through them. For example, Exhibit 1 of the complaint is in the form of a letter. It's on the candidate's letterhead. It's written in a first-person narrative. It invites the public to, quote, contact me directly, and it provides the candidate's or his campaign's phone number, email, salutations from the candidate. All of these things are kind of the hallmarks of this is a representation to the public that the candidate is the one speaking or not somebody on his behalf. Exhibit 2 also, excuse me, the candidate's logo or his campaign logo. You have evidence before you in the form of sworn complaint that the candidate himself and his volunteers were personally handing out this literature to members of the public, which tends to points us towards a standard of coordination or cooperation in these materials. Exhibit 3, again, is written in the first person. You've got more of the candidate's contact, the candidate or his campaign's contact information. You've got a reference in that exhibit to an endorsement of the candidate by Senator Brown that, according to the evidence before you, was not publicly reported or made available elsewhere. Again, further pointing us towards the coordination, the cooperation route. And then the final material or item is Exhibit 7, or is referenced to Exhibit 7. It's yard signs. And again, the evidence is that the candidate and his volunteers were physically putting these signs out in the community on election day. And I would submit to you, ladies and gentlemen, that all of that is strong indicia and the indications that there is a reason to believe that these materials are produced with the consent or in coordination, cooperation, and consultation between the PAC and the candidate. Now, against all that, the respondent really presents nothing. There are no affidavits from the respondent. There are no, or anybody associated with it. There's no sworn testimony. There are the arguments of counsel But the arguments of counsel are just that. They're not really evidence. And I would suggest to you that there are reasons to disbelieve the explanations that are put forth in any event, because it is somewhat difficult to conclude that a longstanding, sophisticated PAC with 6 figures to spend would not include a proper a proper disclaimer in an independent expenditure. I think the better read of the facts as we know them and as you have before you is that the reason the materials don't indicate that they were not prepared or that they were not authorized by any candidate or candidates committee, because that's not true. They couldn't say that. So I go back to, in summation, I go back to the question, which is how do you resolve the factual dispute here, which points us down one road or the other. What I would suggest is you have the evidence on one hand on the complainant's end pointing towards cooperation, consultation, coordination that suggests violation, the in-kind series of violations. Balanced against that, you really have no evidence at all, just the arguments of counsel that aren't supported by any sworn testimony or any evidence. I received this morning a response from the candidate. I've not had a chance to look at it in great detail, although I do note that it is at least potentially notarized. I don't see a notary seal, although I do see a signature. However, all of that said, what I would suggest that the proper disposition here is find that the materials are in-kind contributions and the series of violations that flow from that at a bare minimum. If the commission believes there's further factual development that's warranted or necessary, or that there's factual dispute or uncertainty, then hold it over for a full hearing to resolve those kind of issues. Unless there are any further questions, I'll thank you.
Questions by the committee? Thank you,
Thank you.
Mr. West.
Thank you. Director or Chairman Price, Director Richter, members of the commission, James West, I represent the council leadership fund in this matter. The council leadership fund erred in its disclaimers, and that's really the only evidence that's in front of us. The complainant has presented no actual evidence of any coordination with regard to any of the mailers or the yard signs. Instead, she claims that the existence of the mailers themselves are evidence of coordination simply because they impersonate the candidate, which, as we know, is now legal under Ohio law. And in her original complaint, which is attached as Exhibit A to our response, she actually accused them of doing that impersonation under 3517.20B. It's pretty clear that she doesn't know what the violations are. She is simply saying, I know they did something wrong. I have no personal knowledge of a specific violation of Ohio law, which is a requirement when you complain for the commission. With regards to the second mailer, as opposing counsel indicated, she claims to have seen the candidate pass it out on 3 separate occasions. And yet, rather than include one of those pieces that she supposedly saw and was able to examine closely to see the disclaimer, she did not attach one of those, even though she saw it being done on 3 separate occasions. Instead, she attached a mailed copy that she received from a voter in Ward 12. And with regard to the third violation, the third mailer, she claims that, again, there was coordination and we filed a false report with regards to it. But she also says, despite specifying that it was during the pre-September primary reporting period, it is uncertain at this time as to when this piece was mailed or when the coordination began. If on or before August 25th, 2021, then it was within the pre-September primary reporting period. If a complaint cannot prove that it was within the reporting period, they cannot prove that we filed a false report and it must be dismissed. The same issue is true with the yard sign. She offers no evidence other than a statement that she saw people putting out yard signs. She offers no indication on why she suspects they were Franklin County volunteers and not funds volunteers. So again, there's really very little evidence of that. There is evidence of the disclaimer violation. The fund has admitted fully that it erred in how it prepared its disclaimers. It was not aware of 3517.105. It put its disclaimers up in compliance 3517.20 and left out the statement not authorized by any candidate or candidates committee. It has admitted that, but because it did make an effort at complying, there was no effort at concealing the source of these expenditures, it would ask the commission to, at a minimum, reduce the fine by half for the parties claiming to include. And ideally, since the commission has taken proactive steps, retaining counsel and implementing procedures for future occurrences that the commission should find a violation, but impose no fine on the dog show. If there are no, at this time, I welcome any questions.
Questions by the commission? Thank you, Mr. President. Mr. Martin.
Originally, when I reviewed these materials, I was recommending that the commission set them out for hearing. After receiving the response from Mr. Frank Kelly this morning, changed my recommendation to dismiss Mr. Frank Kelly and based on the materials that were present before us, and find a violation against the fact and impose a fine. I'm still a little unsure as to whether there wasn't a sufficient showing by the complainant that at least the commission could look further into the potential for coordination here. But that's my recommendation. I'll stick with it at this point. The commission members can ask me any other questions that they may have.
Okay, just so clear, what you're recommending is to dismiss the respondents, Brancatelli and friends of Brancatelli, find a violation against the council leadership fund and to impose a fine of $50. That's your recommendation at this time.
Correct.
So, thank you. Commission, questions of Mr. Ricker? If not, do we have a motion?
So moved to follow these.
With a motion, do we have a second? Second. All right, we have a second. So motion's been made and it's been duly seconded. That would follow the recommendation of the executive director, which would be to dismiss the respondents, Brancatelli and friends of Brancatelli, find a violation against the council leadership fund, and to impose a fine of $50. Further discussion on the motion? If not, all in favor of the motion signify by saying aye. Aye. Opposed, same sign?
No.
Motion carries by vote of 5.
5-1.
Next matter on the agenda is case number 2021D-015, Reimer, which is at
Mr. Chairman, members of the commission, the complainant in this case asserting that the respondent did not include the proper disclaimer on a campaign mailer. The respondent submitted a response, which indicates that this is the first attempt at seeking political office. And the failure to include a disclaimer was an oversight, unintentional, and it was surprised. First stopped using the material and eventually got a sticker placed on there. I see that Barry Adler, who is the respondent, is present. If the commission would like to hear from Mr. Adler, he can be sworn, and the commission can hear from him further, aside from what I've already outlined.
Thank you, Mr. Richter. Mr. Adler, would you like to be heard? Would you please swear the witness?
You swear from tell the truth, tell the truth, and nothing but yourself, God.
I do. I submitted a sworn affidavit, basically to summarize that. This is my first time running for the trustee. It was an oversight, claiming ignorance of the law. It was a violation. I moved as soon as I found out about the oversight to correct the problem. That's been dealt with.
Thank you, Mr. Adler. Just anybody, the commission have questions of Mr. Adler? Anything further?
No, my recommendation is to find a violation, but for good cause, not impose a fine or for the matter for the prosecution.
Commission.
I move that we follow the executive director's recommendation.
Second.
We have a motion that's been duly seconded. Follow the recommendation of the executive director, which would be to find a violation, but for good cause, not impose a fine or refer for prosecution. Further discussion? All in favor of the motion signify by saying aye. Aye. Opposed, same sign. Motion carried by vote 6-0.
Thank you, Rick.
Thank you.
Thank you. Next matter is case 2021D-016, Keel versus Case. Mr. Ritter.
Mr. Chairman, members of the commission, in this complaint, complainant asserts the respondent did not include a proper disclaimer on campaign signs. The respondent submitted a response, states that the respondent indicates she moved to Ohio from New York with no disclaimer law. And further, the candidate states that she receives information from a quote experienced elected official and informed that only online material is required of disclaimer. Obviously, that information is incorrect. My recommendation, no party appears to be present. Is there any party present here for 2021 D016?
Just a minute. Oh, hand.
Oh, Ms. Keel,
You want to
okay.
go forward, ma'am?
Did you want to speak to this any further or?
I do not.
Okay. My recommendation is to find a violation, but for good cause, not impose a fine, or refer the matter for further prosecution.
Questions of Mr. Richter about the commission? Not, we'll entertain a motion.
I move to follow the assembly members' recommendation.
All right, do we have a second to the motion? Second. We have a motion that's been duly seconded that would recommend following the recommendation of, or that would follow the recommendation of the executive director, which would be to find a violation, but for good cause, not impose a fine or refer for prosecution. Further discussion? All in favor of the motion signify by saying aye.
Aye.
Opposed, same sign. Motion carries by a vote of 6-0. Moving on, I note that there's two cases, Jensen versus Falata. Did you want to take those separately? Mr.
Yes, I
Richter?
wanted to take those separately, Mr. Chair, and the primary basis for doing so is, in the first case, 2021 D-017, there are two parties that are respondents in the case. There was a joint piece of literature that was circulated allegedly without a disclaimer. That's what the complainant alleged. The respondents indicate this is their first attempt at teaching political office. Failure to include a disclaimer was an oversight. I'm synopsizing here, but the candidate admits their failure, but also state that they were apprised of this disclaimer and stickers were placed on the material within 20 hours. And so in that case, I'm recommending that the commission find the violation, but for good cause, not impose a fine or refer the matter for further prosecution.
Okay, so with respect to 2021 D-017 Jensen versus Falata et al., the recommendation is to find the violation, but for good cause, not impose a fine for prosecution. Further discussion of Mr. Richter?
Good point. Is there anyone present here on 2021 D-017 Jensen versus Falata et al.? Other party. Spencer. All right, this Michael Palmer was the second respondent in that case. Michael Palmer.
All right, doesn't appear that there's anyone present. We've heard the recommendation of the executive director. Is there a motion to be made?
So moved.
We have a motion, follow the recommendation of the executive director. Is there a second?
Second.
She's been duly seconded. For the discussion, all in favor of the motion to follow the recommendation of the executive director, signify by saying aye. Aye. Opposed, same sign. Motion carries by a vote of 6-0. With respect to case 2021 D-017 Jensen versus Falata, Mr. Richter.
I asked the questions. No, that's so it's the same case number, and that should be the 2021 D-023. I'm already.
Let me read that again, just for the record. Calling case 2021 D-023 Jensen versus Falata. Mr. Richter.
Phil is full of mistakes this morning and a bad day to do so, obviously. Well,
We knew your evaluation.
yes, I know. I should have done a better job at getting into all of this. In this particular complaint, this was filed by the same Mr. Jensen against the same Mr. Falata, but this was on an individual flyer that only Mr. Falata was responsible for. We did receive a response similar to the response in the previous case from Mr. Falata. This is the first time candidate, was done hastily, was an oversight. Well, in this case, I'm recommending that we find a violation, impose a fine of $50, as we are looking at a second complaint against the respondent. I'll be ready to answer any other questions that the commission may have.
Questions from Mr. Richter? All right, entertain a motion.
He doesn't say that they, sorry.
No, go ahead.
I'm delayed. This one, they didn't say that they got stickers on right away and did all that, right? I didn't see that.
I
in
don't-
the response.
I mean, I didn't include it in my synopsis, and so if, normally that's something that I would include as I was synopsizing. And he didn't include.
Did he respond to this complaint?
Yes, he responded. Today I'm writing a response, handmade flyer that he personally put together for an event on October, and yes, it was collected and the disclaimer. An apology was offered.
So if he said it, it might not have been, we might have been one of it.
I was gonna say, I think what.
I remember seeing that response to that.
It was handmade, that county Pacific.
It's happening now.
For an event, is that what you?
Yeah, for that.
I think it was for an event. No, it doesn't say that it was for an event. I mean, if you look at the original piece, you got a copy, obviously. There it is, right there, if you want to see it.
Yeah.
And there, there was no disclaimer on it. So, that's my recommendation. I appreciate your.
So his response was, I was in a hurry.
What's my bad?
Yeah,
I corrected it, I did, because it was, you're saying it was a single event flyer.
well, I thought that was included in there somewhere, but as I'm reading back through. I think the other one maybe was for a particular event. I know that was in one of the cases.
One on this one is not, it's just a general flyer.
It's just a general flyer that he did hastily, even, he said so in his response.
But there was no information that he corrected it or did anything.
No. All right. Being that this election is over, I think all literature has already been disposed of. An apology is offered. But he doesn't indicate anything else as it relates to. Correct. Correct.
So you still stay with your recommendation, that final violation that goes $550.
Yeah, that's where I am. But certainly if the commission understands, needs to go a different direction. Okay.
Further questions or comments by members of the commission?
Move that we follow the executive director's recommendation.
All right. We have a second to the motion.
Second.
All right, we have a motion that's been duly seconded that would follow the recommendation of the executive director, which would be to find a violation and impose a fine of $50 for the discussion by the commission. All in favor of the motion, signify by saying aye. Aye. Opposed, same sign. Motion carries by a vote of 6-0. Thank you. All right, moving on to consideration of frivolous fine in case number 2021G-003, Hugh Bay versus Bainbridge et al. Before we get into the case, I believe we had 2 recusals when we heard this case back on June 24th, 2021. So recusal still in place.
Yes, Mr. Chair, Mr. Cunningham is recusing himself.
Scott Northern, I'm excusing myself as well.
All right, so the record should reflect that both Commissioner Cunningham and Commissioner Norman are recusing themselves. The record should reflect that they are leaving the hearing room. Will be available for the next case. All right.
One minute around text me.
Go ahead. All right, I'll let you leave. All right, just by way of background, this case is before the commission for the sole purpose of determining whether the matter should be declared frivolous after the commission dismissed the case at the June 24th, 2021 meeting.
Yes.
And
Started the meeting. 4, so it takes me also.
Yeah.
It's been very hard.
Sorry, I'm slow. I want to back it.
just notice I was a lot faster.
Good at it.
I know. I have an ask, I'll ask you to say you were out here early.
We started the meeting with, we only have 4 to act on this particular case. But we
Can't take action.
I believe so. Yes, we've done it before.
Okay.
The quorum was commenced with all members
No, I
present.
understand that. But we're going to make a decision based on lack of.
We've done this before. It's been very rare when we've had sufficient. Anyway, the conversation we're having right at the moment is whether there's sufficient quorum. The commission is obligated to meet with a quorum, which we did with 6 persons, 6 of the 7. In order to take an action, though, the commission has to have 4 persons decide on a particular case. And so we've got 4 of the 7 present to take action. So it would just take an action by all 4.
So the action has to be
It
unanimous.
has to be unanimous. That is correct.
Okay. Mr. Director, go ahead.
This case was before the commission in June. The commission dismissed the complaint at that time. Concerns were expressed about the nature of the complaint. And so the commission decided to reset the matter for further consideration as to whether to find this matter frivolous or not. That is the only thing that is before the commission today. The commission's story comes under section 3517.155E, where it says in an action before the commission or a panel of the commission, if the allegations of the complaint are not proved, the commission or a panel of the commission, obviously it's the commission, may find that the complaint is frivolous, and if the commission or panel so finds, the commission shall order the complaint to pay reasonable attorney's fees and to pay the cost of the commission or panel as determined by a majority of the members of the commission. Again, 4 persons for a majority. And so that's where we are, Mr. Chair.
Do we have the parties present? And
There are a variety of people present that were respondents and or representatives of the respondents. Ms. Wilhelm is present on behalf of the complainant. Looks like the complainant is present as well. And so can proceed in the manner that you believe appropriate. I guess my recommendation would be we hear from the various respondents as it relates to their particular position on this initially. If they are, if it's counsel, obviously we can hear from counsel. If it is an individual, we would ask that they be sworn and make a statement, and then we can hear from Ms. Wilhelm as it relates to her approach to this matter.
sounds good. Anybody have any commission members object to that procedure? All right, let's go ahead and proceed with the respondents. Who do we have present?
Well, we have listed present Brian Bainbridge, Tim Bainbridge, Tara Wood, Mark Johnson, Angela Langtot, and Todd Walter. I don't know,
Andrea Helford.
Andrea Helfrich as well. Okay. I guess I'd be inclined to say, let's hear from whoever may be represented as counsel first, before we hear from any of the individuals. And so, I know when Mr. Walter, Mr. Johnson, and Thomas Bainbridge are counsel. I'm not sure of anybody else that's present with counsel. So,
Okay, let's start. Mr. Walter, are you present? Please come forward.
They've been supplied with what we provided the other day. Have they seen our brief?
I think the answer to that would be no, because I know I have not been otherwise
Okay.
available.
Everyone make
It hasn't been asked for, I haven't,
Okay.
Can we take a quick opportunity?
Yeah, why don't we do this? Let's take a 10-minute break, okay? And if we need more than that, we can take about 10. But let's start for 10. Ms. Wilhelm, if you get that copy to them, we'll do the same here. I'd like to have counsel for the respondents. Please take a look at the brief that's filed by Ms. Wilhelm. We'll take a 10-minute break.
Yes, yeah, I wasn't served with one. I served my copy of the statement by email on Mr. Hudak.
Yeah, we saw that.
Yes, I sent that to her. I sent that to her yesterday or the day before.
One, two.
Yeah, we're. See the package.
Yes.
I just took it out.
Okay.
I'll be careful. RFP. Any other opposing counsel?
Yeah, we're gonna.
Yeah. Well, we thought of it. We didn't know what it was.
You had a conference, so she's not coming.
Oh.
Which I didn't, I guess that was passed along to Chris, he probably passed along, but I. Overlooked it.
Should we do some research then at some point?
At some point.
Submit it online.
And do any of the commissioners need a printed out copy? Because I know Mr. Richter emailed it to you.
Oh, I have a copy.
Okay, we have
Everybody else
extra.
have a copy?
We have extra physical copy.
Yeah.
That seems a little now.
Okay.
A pretty copy.
Okay.
Please now.
Yeah, if you have an extra copy,
Sure.
I'd take it.
We sure do. I will be in here.
Good night. I'm just feeling froggy today.
Yeah. We are off the record.
Oh, yes.
Oh, yeah. Not yes, oh, yeah.
I'll respond to her. I had a conversation with her about that. She like trail. She looks.
Would you like me to put a mask on or?
I
read that too. Yes.
I was responding. I was responding in her behalf.
He
didn't let me finish.
Your card.
I don't have my card. I do. It's not notarized, but I have it.
Oh, wait a minute.
All
You
right.
can see that as an introduction.
All right. Anybody else need a physical copy?
Brief.
I don't have
Affidavit,
that. I need everything.
no, 3 exhibits.
Oh, yeah, I have all that. Yes.
I'm going to do that. For a while, I think it's a different. No, I did, but I got
Not
it.
offensive.
Yeah, I don't like my partner. For a while, I was carrying it more well, it was. And so I.
You should put it in your purse. That's what I did.
Thanks, I'll keep that.
Great idea.
After I get home, when I get my purse out.
All right.
Keep that, keep that at home.
That's a pro tip.
Please, my wallet.
I feel like they should make them so it's like a credit card size.
It would have been a little bit more beneficial.
Right.
Like I said, I carried mine a while and it stuck out, so it kind of, yeah, so I stopped carrying it.
Because they use the same one when they do boosters, right?
When I did that, they put a little strip, you know, like a.
Okay.
Yeah.
So, right, if-
I didn't. I was. Advisor.
So that's what I have.
You know, I didn't do systems.
Good things. My score, I've got CLE. I think it's 50%.
Which, oh, it's like Pfizer. I did Johnson and Johnson. Not a big fan. Yeah. Needles, so.
My son shopped around when he was, couldn't finally found a place that was like off Johnson Johnson like day, so that's his Pfizer appointment.
Yeah.
When counsel for the respondents are ready, just let me know. I'm not rushing. I'm ready. Once you're ready, we'll go ahead and get back on the record.
No, I just wanted to make sure. I just want to make sure. Okay, the other council ready? Okay, let's head nods. All right, let's go back on the representative, please. All right, at this point in time, Mr. Waller, are you ready to proceed? All right, go ahead.
Commissioners, Executive Director Richter, thank you for the opportunity to speak to you today and your service to the community. My name is Todd Walter, and I'm here representing my wife, Nicole, who is named in this baseless complaint. I'm disappointed to have to appear to you today, but I believe it's important for several reasons, including matters of principle and precedent. I've been a practicing attorney in the state of Ohio for 17 years. Fortunately, I'm a transactional. From my perspective, so just trying to.
Hey, Charles. I'm good. How about you?
Apologies.
Are we back? Sorry about that. Sorry about that, Mr. Wallace. Go ahead.
So I don't have to engage in these types of matters often. I can say, however, that in my 17 years of practice, this is among the most egregious behavior that I've seen by a member of the bar. The conduct by Mr. Cube was an abuse of power against members of the community, an abuse of process against this commission. If it is not dealt with harshly, it will set a precedent that could lead to a rash of similar behavior. As noted, today, we're here for the sole purpose of determining whether Mr. Cube's conduct constitutes frivolous conduct under Ohio Revised Code 2351 and Commission Rule 3715-1-3. The facts at issue and the complainant's own comments at the hearing clearly demonstrate that the conduct was frivolous. As others will speak to in responses such as those presented by Mr. Mark A. Johnson thoughtfully and clearly lay out the legal basis for frivolous conduct. In the interest of time, I won't rehash each of these points, but I do want to highlight a couple. One, the complaint, he filed a complaint with the OEC in which he affirmed he was doing on the basis of personal knowledge and subject to penalties for perjury. Mr. Cube admitted to the commission that he had no knowledge of alleged misconduct by any of the individuals identified on the basis of their membership in a face group, which was formed on an unrelated matter. It is my understanding that certain individuals have indicated they were not part of that Facebook group and yet are still in the complaint. If that fact is true, Mr. Cube misrepresented to this body the basis for his complaint, which could go to 23 and 2351A. The complaint serves merely to harass or maliciously injure another party. More on this later. Mr. Cube also misrepresented to the commission his behavior. To wit, Mr. Cube informed the commission that he dismissed those that contacted him. That is not true with respect to me. I called him prior to this matter prior to me filing a response to this matter, and I did not hear back from him. Just before this, Mr. Cube did apologize to me for not returning my call, but the facts are I wouldn't be here had he returned the call. Further, and perhaps most disappointing to me as a member of the bar, was Mr. Cube's disappointing statement that his conduct was justified because this is not really litigation and it does not require legal counsel to respond. I find this conduct highly offensive. This is an abuse of power and a perversion of complainants' legal freedom. I happen to be trained in this area and know why I don't practice in it. I can read a statute. What happens to those that aren't so fortunate? Other respondents had to hire attorneys, spend dollars to respond. You get served with a certified mail that says official legal or important legal document. You get a complaint in there alleging you violated the law. You get rules of procedure, which gives me PTSD to my civil procedure class 20 years ago, and a stack of statutes that you have to wade through. Merely for being a member of a Facebook group? So I'm not sure what necessitated this action, This is a municipal election in Columbus, Ohio. Mr. Cubey resides in Cleveland. But a couple of things, from my perspective, there's three scenarios of this conduct. One, and all of them lead to a finding that it's a frivolous conduct. One, he didn't do the work and didn't do the investigation and find facts necessary to meet the elements required to file a complaint. Two, he misapplied the law and the facts. Or three, he maliciously and harmfully targeted a group of individuals with an opposing political or policy views and abused his training as a lawyer in the process with this body to further his interests or those of his clients, if applicable. This is not a victimless action. While I know some of the respondents, many of whom I don't. The one I know the best is my wife. So I'm going to speak about her. And she would never say this, and I'll probably be mad at me when I get home. But she was raised in a small town, paid her own way through college, worked in an inner city school in Washington, D.C. for 2 years, teaching those who are disadvantaged. Paid her own way through school on a master's degree, taught in a rural district in school psychology, taught in a rural district and a socially, economically disadvantaged school district in Columbus, and devoted her entire professional career to helping kids. So when the pandemic came and affected all of us, she had a background in the training. We saw how our kids were affected, a kindergartner, a second grader, and a fifth grader. And she knows the importance of those early training years for kids from her background. And she wanted kids to have an opportunity to be in school for 5 days a week. That was her purpose in being in that Facebook. Just like the Catholic school opened a block down our house was. Now, you may disagree with her. You may think her views are crazy. But what it is not is a violation of election law. And so for that civil discourse, she got brought before the commission. I'll also note that 28 of the 36 people named are women, and I'm not one for identity politics, but I suspect many of them were in the same situation. And if their house was anything like ours, the burden that happened fell on those more than it did me. I say this not to praise my wife or anyone else who certainly deserves it, but just to describe the human element of this type of conduct. This is character assassination. It impacts people's reputation, jobs, and relationships. One of the things that's always troubled me about the legal system is those that have means have better outcomes. But what happens when these complaints get brought against people that don't or aren't trained? So I don't know if this was malicious conduct or not, but I do know the commission doesn't need to find that. Clearly, the facts established show that these allegations have no evidentiary support and factual contentions that are not supported by evidence, at least with respect to my wife, who's the only person I'm here with. With most traveling is not only did Mr. Cubey's actions lack the judgment and required elements to file this complaint, his actions lack decency, empathy, and compassion. I urge this commission to act accordingly, to find this conduct frivolous, to award Mrs. Walter an amount equal to her attorney fees and costs, which will all be donated to charity, and refer Mr. Cubey to the Ohio State Bar Association for misconduct. Should you award any funds to us, we'll donate them to Peloton. We've been supporters for more than a decade, and that's been a ride. One of the things, not only do I support it because of the innovative cancer research, but also because it's one of the few events that brings the community together. And as we live in a hyper-partisan world, I think it's up to the institutions to protect the world from breaking down. And if this body can be used to silence speech against those people don't disagree with, it's an unfortunate result, and this will just continue. Thank you for your time.
Thank you, Mr. Walter. Just a second. Commission members have a question, Mr. Walter? No. No? All right. Thank you, sir. All right, Mr. Johnson.
Good morning, Mr. Chair,
Good morning.
Members of the commission, thank you. I'm Mark Johnson. I'm here on behalf of words I thought I would never say in my life. Respondent Deborah Johnson, my wife. Thank you for having me, and I'm going to be very brief. Words that attorneys often say, but I really do mean that. Before I hit a few points, I also want to, and this is something that I think is important in oral argument, is
Chairman Price, could I interject something here? I'm a little confused as to whether he's party because he was never served before the initial meeting, and the case was dismissed at that meeting. It was a party that was never served. By the time anything would have made it to him, which it probably shouldn't have because the case came dismissed.
Well, we did receive the amended complaint that included Ms. Johnson prior to the commission taking the matter under consideration. We didn't serve it on her, correct? But she was included in the amended complaint. And so therefore, after the commission decided to dismiss the complaint, it was determined that we would circulate a notice to all parties who had been included, and she was included in the.
Okay, it would certainly make no sense for someone to incur legal fees though, after they've been dismissed from a complaint.
Well, I think we'll get to that. If there's a determination from misconduct, you're exactly right. Mr.
Okay.
That would be something we'd have to consider.
to clarify, the respondent is my wife, Deborah Johnson, not me. And I do end in here, and council raises a good point. I am appearing for the limited purpose of responding to the commission's notice about consideration of frivolous finding, because she has not been served with process in this case, but she was in fact named with a complaint, which was sworn under oath, subject to penalty of perjury, accusing her of things which of course she did not do. Just a couple of highlight points of the statement that we served and filed last week. Intent is not an issue under the frivolous conduct statute under two of the different elements that apply here. The lack of an evidentiary basis for the allegations in the complaint, which this commission already found there were no evidentiary basis for those allegations. So whether Mr. Ube had any intent or malice to hurt anyone or just plain made a mistake does not matter. Under the frivolous conduct statute, those are dead on. Both of those elements are met with respect to whether the conduct is frivolous or not. I listened to and I watched the Facebook, or I'm sorry, the hearing on Zoom, the June 24th hearing. Of course, we didn't have service, so I couldn't have appeared to be there or to watch in person. Either way, and I was aghast, and I think this commission was as well, that several opportunities and several questions were asked of Mr. Ube. What was the factual basis for your complaint? And it kept coming around to this screenshots of Facebook pages, and which Mr. Richter was kind enough to send to me in advance as well, that appears that have also now been submitted as Exhibit C for the complainant as well. I looked through this and I can't find my wife's name anywhere. My wife served on city council for 8 years, so one has to question, how did she end up on an amended complaint that the sole factual basis for are screenshots of a private Facebook group, an amended complaint of alleging election law violation? It starts to get more and more attenuated to the point at which the thread simply snaps. There is no basis. Couple of things, and I heard comments I heard from Mr. Ube, and I'm sure he would probably put on his heels during that hearing, and as any attorney would when they're caught unawares. He described it being too hard to identify who violates the law in these situations, and there was some discussion of that. And I appreciate that, and not being an election law lawyer, but a class action defense lawyer, when reading the statutes, I can see that could be difficult, but I also saw where this commission adopts the discovery rules of the Ohio Rules of Civil Procedure. So there were bases to determine, and in fact, to try to identify who were the individuals that may have been responsible for this mailer, which we received in our household for the first time in the mail when we lived in Upper Arlington. But it doesn't appear that any of those measures were taken. even a simple phone call, if Mr. Ube said, I'm considering adding you, Deborah, to this complaint for violating election law. You know, it's pretty easy to find people nowadays via Google or otherwise, but particularly somebody who's an ex-elected public official, and ask her, he would have given her this, she would have given him the same response. I had no idea what this mailer was going out or anything about it. Saw it for the first time when it arrived in the mail. None of those things happen. And that's basic blocking and tackling. In terms of litigation practice, of having a good faith basis for the allegations in a complaint. Even when one signs a complaint without it being under oath, based on personal knowledge, subject to penalty of perjury. A couple of things that I think are probably, and Mr. Walters touched on these, I think are probably more important, is to make sure that there's not another Scott Hube who finds that I'm going to file this blanket complaint against any number of people. And instead of me having personal knowledge of whether they violated the law, I'm going to make them come forward and appear to the commission and swear under oath that they had no knowledge of it. And then I'll be kind enough to release them from the complaint. That's not how it works. That's not how the statute is set up. And that's not how the statute requires complaints to be required to be presented under oath. So at a minimum, I think a finding of frivolous conduct needs to be made to, I hate to say make an example, but at least to make clear that the commission's rules and the statute that it follows mean something. They really do mean something when you swear under oath, subject to penalty of perjury, that you have personal knowledge of something. Now, what sanctions might issue from the commission, that's completely up to the commission based on what they hear from Mr. Ube. I'm not empathetic to a young lawyer who's a sole practitioner, sometimes pushing the envelope. I've seen it over the past 36 years, probably did it myself 30 some years ago, but I had somebody to bring me. And so I'm not empathetic to that position of a younger lawyer who's by himself, who maybe doesn't have a ready mentor to help him find his way in path of the correct path, or what is your proper path. But I guess part of it depends on his response today. And I was really disappointed to read this very quickly to see his response is not that I'm sorry, I didn't really think this through, but rather I did what Mr. Richter told me to do. And I don't know what to say. I guess I can't defend Mr. Richter because he's not my client. But from my standpoint, when statute requires it to be under oath, subject to personal knowledge and subject to penalty of perjury, it doesn't qualify to say, but Mr. Richter said to go ahead and file this. So I'll leave that for the commission to decide. The one final comment I make, and this is one of the more broad reaching comments, I think, that applies here. This is not a red-blue issue or blue-red issue. This could just as easily be a group of folks from what may be identified with another party filing the same thing against the same party. So it's not a political issue. It is an issue of what's right and what's wrong, and making sure that we're sending a message to the community that it's okay to have a free and full discourse in public, particularly in social media, without being subject to these type of allegations. Happy to answer any questions, respond to any thoughts the commission may have.
Thank you, Mr. Johnson. Questions of Mr. Johnson by members of the commission?
Thank you so much.
Thank you, sir.
Thank you so much for your time.
Mr. Bainbridge, Thomas
Can I
Bainbridge?
also speak on my own behalf? He's gonna say something.
I'm sorry.
Am I allowed to also speak on my own behalf? He's gonna say something. I'd also say something.
Your name?
Brian Bainbridge, I'm sorry.
All
Yeah,
right.
Brian Bainbridge. He's my attorney, but I'd also like to say something. as
Okay,
well.
that's
my
fine.
name's on the top.
You want Mr. Bainbridge, the attorney, go first? Or
Yeah,
you
you
want to
can
go
go
first? Okay, that's fine.
I always thought he was gonna be an attorney, but he's not.
Yeah. Yeah, well, that's where you're here today, though, acting as his counsel.
Right.
All right, thank you. Go ahead, sir.
Well, I don't know what they had to do, two eloquent attorneys that have already spoken, but I would like to say a few words. Always want to watch an attorney when he says, all I want to say is a few words. But I'm limited to a few words. Our family lives in Upper Arlington, obviously. we've always tried to do what is best for the community and elected officials in our community. We've been involved in politics at least my whole life, and I have 3 sons, and they are also involved in politics, as is Brian. And my only regret is that Brian's name shows and the title of the case here, so we've had to deal with that as the named defendant. But over the years, I've been blessed, and I've tried to teach my kids to emulate the involvement that we need in the political process in our community. I was fortunate to be appointed by Governors Voinovich and Taft to the Board of Directors of the Bureau of Workers' Comp. The Supreme Court appointed me to be Commissioner on Victim of Crimes. We hear victim of crimes cases. And Governor Casey has appointed me to be Chairman of the Industrial Commission of Ohio. I don't say this for my own glory or fame, but I want to portray this as the way I brought up my 3 boys. And Brian has elected to follow somewhat in those footsteps, in that he's become very involved in Upper Arlington politics and county politics too. All of us have tried to do our best in making sure our community elects proper city council, board election people. We try to be involved in that process as a family. I'm sort of concerned here about what the issue we have before us. I think 23.51 is extremely applicable, and I would urge each of you to study that statute in making your decision. That statute says that an action is filed before this body, and it's obvious that this action is filed to harass people, and then the 23.51 certainly indicates that you can't use this body to harass other people. It has to be a good faith argument, and I don't think we have that here. There's no evidence to support the facts that have been alleged. It can't be frivolous, which in my opinion, it certainly is a frivolous action that has been filed, and would urge you to find the other party involved, call them a plaintiff or defendant, that this is truly a frivolous action, and we can't let actions like this go on, or your dockets are going to be extremely filled. We have to put a stop for this. Thank you, commissioners. I certainly appreciate your attention and effort in this.
Thank you, Mr. Bainbridge. Any questions of Mr. Bainbridge? Thank you, sir. Mr. Bainbridge, too.
Thank
you.
you.
Please swear the witness.
You'll be sworn in. You'll be sworn in.
Please raise my hand. You swear from the time of thing, but I please not yourself that.
Yes, 100%. So, just want to thank my dad for speaking. He did make a good point, is I have always been someone that's been involved in the community. I was very involved in the West Side before I moved here to Upper Arlington. Really new person in the community. 2019, I moved to UA, and I didn't really know that many people. One thing that I've always tried to get to do is get involved in something I believe in. And the thing that I believe in a ton is education. My kids are 4 and 6. And really, I think my biggest, and probably got from my mother, is I didn't want to see them have to, thank God my son's in kindergarten this year, but I didn't want to see them have to sit in a virtual setting for kindergarten. So the main point of me, and my friend here, Scott Ube, I don't know, and he doesn't know me, decided to just pull, just completely out of context, a community meeting that I helped organize to help get our kids back in school last year. That's all it was. I mean, we were a lot of parents that were, that had teenage kids. I know Tara here. It's one of them, Tara Wood. I'm just going to speak. We saw our kids just sitting there each day looking at a computer. And that right there was trouble. I think the biggest, when we got that meeting together, that's what we were meeting for, is what can we do to petition the school board to get our kids back in school. That's it. There's some sort of belief that there was a mailer sent out that I knew nothing about. I learned about it just like Mark Johnson said. I learned about it when you guys sent it to me in the mail. I had no idea that mailer even existed until I got it in my mail. So I'm just like, oh my gosh, I'm responsible for a letter that I didn't even send out. Just because someone, and he's not even part of the community here, he's not even on that Facebook group. I know he has friends possibly that probably fed him that information. But when you look at that Facebook group, it was all about 5 days now. Had nothing to do with anything else on that note, whatever it was. They had something to do with the bathrooms. But when you look at the purpose of the group, and the purpose of the meeting is 100% for us to get together as a community and try to petition the school board to get our kids back to school. I personally think that some of the things that he has been doing is just taking kind of like a Joe McCarthy approach. I was before my time. I do apologize. I don't know if you guys remember that, but take a Joe McCarthy approach to what he believes is right in his own mind to try to attack people in the community for some sort of thing that he's upset about, and just pulling people out of just a random Facebook group and putting us on this complaint. I can't, in my mind, think about the failure in logic and the jumping to conclusions more than anything else that I've ever experienced in my life, just based on us chatting about getting together. And the last time I checked, and we're in America, it's not illegal for us to convene as a body to talk about things that are concerning us with the school, especially the matter being that our kids are sitting at home, not in class. So that's pretty much majority of what I wanted to talk about. My biggest question is that, I'm involved in the community. My dad says I'm involved in politics. I'd like to see myself as a community activist. Ran for office in 2013. I haven't ran since. So really my political involvement is all just to try to, just like most people in this world, we'd like to see our community succeed. We'd like to see our children succeed. And that's really my main objective. Has nothing to do with trying to change any political landscape in the U.S. I am involved in the Republican Party, but at the same time, my only involvement with that was just 100% get our kids back into school. That's it. Thank you.
Thank you. Just a second. Questions of Mr. Baker? Thank you, sir. All right, Mr. Rick, do we have any other respondents?
The other names listed on the sign-in sheet, Mr. Chair, members of the commission, are Farrell Wood, Angela, I presume it's Lang Todd, if I'm repeating that, I apologize, and Andrea Helpway. Do you all want to speak? Or you, Ms. Wood?
Yes.
Please go ahead. You're the closest to the top as we're working down.
Please swear to this. Please state your name.
Tara Wood.
Go ahead.
Thank you. I apologize for my decor. I'm a mom. I had mom things to do this morning and found myself with some time to be able to come. So I don't have specifically a formal thing to say to you. So I appreciate your grace and my informality and what I would like to say to you. I would like to just to tell you that if there's anything to say that this is frivolous, I'm it. I am just a mom who at the time had kids at home who were really struggling, and I became a part of a Facebook group that was just trying to help our kids, and we were a group of parents that were kind of collaborating and talking and sharing information. And I suddenly get this thing in the mail that says I'm a part of a complaint about a flyer I had never even seen, about an issue that it wasn't even on my radar, that I wasn't even concerned about. It's not my issue. And I was super confused where it came from, why my name was on this list. I saw my name amongst a list of a large group of people I didn't even know. I'm relatively new to UA. And so at the time in particular, I didn't even know. I think I knew 2 names on the list. I know more now because we're kind of we're all in this kind of same thing. And so I was very confused why my name was a part of it. And then actually it wasn't until 20 minutes ago that I even knew specifically why my name was included when I saw a screenshot of some comments I had made, again, not related to the flyer that was in question at all. It was actually in relationship, as Brian suggested, that we'll get together just again to brainstorm, how do we help get our kids help? How do we get them past this kind of dark stage we were all in? If you all remember what it was like a year ago. And that's what it was about. So it's interesting to me that point 5 on here on this letter that we just saw that was given to us, it says the protocol was to provide a full list of names of the people who I believe may be behind the disclaimerless mail piece. That Facebook group that the screenshots were from had hundreds of parents on that list. Hundreds. Why was my name included? Why was my name pulled from that list? Why was my name made to be one of the ones he thought was behind this flyer? Further, he wasn't even in that group. He's not even a resident of UA, which means somebody gave him that information, which means this is not only a frivolous case that he brought before you, but he's representing somebody else who should also be held responsible for the frivolous nature of this complaint that is wasting your time. This is something that whoever's behind this is using you guys as a means, as a weapon against people that they, whatever reason, I don't know, I have suspicions why. But you're being used to attack people and as a weapon. And I can tell you, I know for a fact, because I've seen it on social media, that there are people who also I suspect may possibly be behind this case, who have already said that they're ready to send some word your way. We had a recent election and they had Facebook comments that have said, and get ready, we're sending more to the election commission. That is happening. They have said that. And so there's a possibility, whether you have it now or it's coming your way, they think that they can use you as a weapon to come at people that they disagree with or that they don't like or that they want to silence. And so as it was suggested, we have to stop this. This is these frivolous cases against people we don't like. And you need to stop them using you as a weapon towards people that they don't like. And I guess that's all I have to say. So thank you for your time.
Thank you. Questions, Nestor? Thank you very much.
All right, thank you.
Next up, sir. Angela Langtot? Langto.
But let's really-
Excuse me. I apologize.
And I am an attorney, so I don't know if I need sworn in, but.
As a respondent, you would need to be sworn.
Yes. So I actually hadn't planned to speak, but my friend, Dr. Kareen, provided me an email, which I know she sent to you, and I don't know if the rest of the commission got to hear it, if that was something that I should read. What is your thoughts on that?
Could we see a copy of that, please?
You need a copy? I got it.
Thank you.
It's an email I received this morning.
Thank you.
Would you like me to read it? What would you want?
The floor is yours, ma'am. How would you like to proceed?
You guys can read it. I'm assuming you're seeing it for the first time since you just sent it this morning, but to summarize, she is a pediatrician and she has never once opposed the bathrooms that are the subject of the mailer that Mr. Dubé filed a complaint about. In fact, she's been very in support vocally. She is in support of children being in school. She lays that out in the letter. So the point in bringing her up is the fact that could not be more malicious to take a pediatrician serving the community, serving children of all needs, in fact, many special needs children in her practice, and to try to associate her with something, because she was in the amended complaint, I should clarify, something that she had absolutely nothing to do with, and if anything was in support of, could be nothing short of malicious intent to hurt, tend to harm her practice, tend to cause her damage in some way. I just want to summarize that on her behalf. And then as far as myself, like I said, I wasn't going to say anything, but when I got the Mr. Dubé's response just a little bit ago, just want to clarify his 2 points that he filed in good faith and based upon personal knowledge. I just want to say on the record that he was not in any of the groups that we were in advocating for our children. I have no idea how he could claim personal knowledge. That was one of the reasons why I wanted to come today, to find out what that personal knowledge was. If he had anything, including these screenshots, that had to have come from somebody else. I, again, don't know how that is personal, as he did not read them firsthand. And secondly, to say that they're supported by evidence and not frivolous. You've already heard from several people, myself included, that we in no way in any of the Facebook posts commented on the mailers in an effort to support them. Our only action in the screenshots was to get our children to school. So I don't know what the evidence is. Again, why I came today, I'm still not seeing it. So if these are 2 defenses, I'm not sure that they're very successful. Thank you.
Thank you. Questions? Thank you very much, Bill.
Ms. Helfrich, go ahead.
Members of the commission, thank you so much for agreeing to hear this. I know that your work on this, on your commission is really a public service for the greater good of the community, and I really do gratefully appreciate everything that you've done with this case and with everything else. My situation is slightly different. You've got other folks that are talking about groups they were in, meetings they were at. I'm not a member of any particular Facebook group. As a matter of fact, I kind of enjoyed having my children home, which I'm outing myself, and that's okay. I was not a 5-day now proponent. I am an educator in Upper Arlington City Schools. I'm a former board member of the Upper Arlington Education Foundation. I'm the parent of 2 girls, a high school student and a middle school student. And I was added, as the amended complaint recognizes, and told by some folks at a sporting event during the summer that I had been mentioned in this. And please understand that when you are affiliated with this flyer, it is a scarlet letter that you are perhaps transphobic, you're homophobic, you're against COVID mandates, you're against COVID protocols. It is not to be taken lightly. And the burden of proof and the onus to prove that I am not one of those individuals then rested on me. I became very concerned, not just for my children in the schools and their teachers and what they would think of them, but also for my own employment. I had to retain a lawyer to see what I could do to mitigate the damage caused by this, to see if I would have to figure out what to do next if it did affect my employment. I spent a couple of months trying to figure out if anybody within the district had seen this, had seen my name. It quickly became clear that everybody knew my name was out there. So at this point, again, I think I'm probably the only one, or at least one of maybe 2 or 3 folks. I'm not on any one of those Facebook groups. I never have been, and I never was, and I wouldn't be, because they could negatively affect my employment, number 1, and number 2, negatively affect my children. I'm a longtime volunteer in the community. I work very hard to make sure my reputation is pristine. And Mr. Hubei, or whoever it is that hired him, demolished that. And for my children, I won't know how much longer this affects my kids. It'll be a couple of years from now and somebody will say, oh, she was named in that flyer complaint. They won't remember it was amended. They don't remember it was frivolous. Once it's out there, it's out there. So I guess I just have two big questions for Mr. Hubei. I see the screenshots you folks have of the Facebook pages, and I appreciate that. Being that I was not on there, on any of those, and we can definitively proclaim that, how did you identify me to be added into this complaint? And the second question I would just ask is why? Brian Bainbridge is a wonderful individual, a wonderful member of the community. And I remember when the first thing came out and everybody saw who was named, my heart broke for him. All he does is try to serve the community, and he is named as the chief complaint in this. And it's heartbreaking. It's everything you have going on in your workaday world. And then something like this comes up and you're just slapped with it. And it's unfair. Good people shouldn't have to go through this. We all work so hard, whether we're Democrats, Republicans, anything, to just make a good community. And it's situations like this that are tearing it apart. I don't care if it's Upper Arlington or Columbus or wherever you are. It's got to stop. And they are, I have heard, unfortunately, over the past couple of weeks, that apparently there's folks on there saying they are bringing more stuff. They're ready to go. And that's just going to create more pain. So anyway, I apologize for taking up your time, but I do appreciate your efforts on this. And I really hope that whatever we do here today ends it and ends this type of behavior. And I thank you.
Questions of Ms. Alfred? Thank you, ma'am. Thanks, Bruce.
That's the only those are the only persons that were included on the site. Mr. Chair.
Okay, is there anyone else there on the respondent side that would like to testify? Because if not, I'm going to turn it over to the complainant, his counsel. Okay, see, Ms. Wallham?
Thank you. Good morning, Chairman Price and Director Richter and commissioners. This was not a frivolous complaint. Mr. Hubei takes this hearing today very seriously. He took the Election Commission meeting on June 24th very seriously. And he takes filing complaints with the Elections Commission very seriously. This is not someone who has a history of filing frivolous complaints or outlandish lawsuits. Instead, Mr. Hubei is someone, when faced with a novel situation, one that he wasn't sure how to handle, did his due diligence and called the source to properly find out how to file a complaint of this nature. He called the Elections Commission and spoke with Mr. Richter to find out how to handle a situation where a mail piece had been sent out, clearly with no disclaimer, in violation of the law, and was likely created by some in a Facebook group that had organized itself around issues against the school district. Now, some would have you believe that it was pulled out of whole cloth. It was not pulled out of whole cloth. The Facebook group discussion included things like talked about getting together, quote, for the purpose of helping to create an organized action committee. A group that talked about selling yard signs. A group that defended the disclaimerless mail piece by citing incorrect law. Why would someone defend the legality of a mail piece if they had nothing to do with it? Why would that even be a point of discussion in the group if some hadn't raised concern? When Mr. Hubei spoke with Mr. Richter on December 8th, he was told to include all of those individuals on the complaint that he believed to be involved and that the commission would send notices to those individuals. If they were replied that they were not involved, they would be removed from the complaint. Mr. Hubei doesn't decide what gets sent out to the respondents. And his understanding was that it was a simple thing that was being sent out that respondents could reply to, given the nature of this specific kind of complaint. When Mr. Hubei was ready to file the complaint, he then again called the Elections Commission one more time on March 25th, prior to filing, with the question with the request that Mr. Richter give a procedural scan. Mr. Richter made it clear that he did not want to give more than a procedural review. And nor was Mr. Hubei asking for more than that. But he said, quote, generally speaking, the format and information is acceptable. No red flags raised. Well, it's not Mr. Richter's job to edit complaints, and Mr. Hubey certainly wasn't requesting that. If there had been a problem such that the complaint was even in the territory of being considered frivolous, and given that Mr. Hubey had asked for information about how to file such a complaint, it's reasonable for him to have thought that maybe a phone call would have been made or an email would have been sent back saying, hey, I'm not sure you understand that you correctly understand the guidance that I gave on December 8th when you called to find out how to file this complaint. These were not actions of someone trying to file a frivolous complaint. These were the actions of someone trying to do it the right way. Mr. Hubey wasn't surprised that the format and information were acceptable because he was following the direction that was given to him in December of 2020 by Mr. Richter, which was to provide a full list of names of the people he believed to be behind the disclaimerless mail piece. He filed this complaint in good faith and was completely blindsided by the June 24th meeting because he had every reason to believe he'd filed it pursuant to the Election Commission protocol. When I watched that meeting, Mr. Hubey is asked several questions and never responds in a highly defensive manner because he thought he did it right. He was trying to follow the directions given to him by the Election Commission. A frivolous finding, even a frivolous hearing at the Elections Commission, is extremely rare. One, maybe two in the last decade have even gotten to be considered. This is hardly a case that rises to that level of egregiousness. Many cases have come before the commission where it is not clear who is responsible for circulating a mail piece or putting up yard signs that don't have a disclaimer. I can remember cases where the commission essentially said to the complainant, yeah, you're right, it doesn't have a disclaimer, and it should have a disclaimer, and it's too bad there isn't stronger evidence so that we can find the people responsible. The disclaimer law is there for a reason. It's to provide transparency to voters so that they can know who is paying for and providing the information they are seeing when a sign or mail piece has to vote for or vote against. Not only did the mailer just not have a disclaimer, but no required independent expenditure was filed either by January 31st. The Election Commission lost the ability to hear false statements several years ago. The disclaimer law is one of the few requirements that assist voters in knowing at least who is behind the information that we're receiving. And it's a law worth enforcing. Again, Mr. Hubey did not file this based on nothing. He, in good faith, thought he was filing against proper people and that it wasn't such a big deal for people to just call up and say, hey, I didn't have anything to do with this. He took those phone calls in good faith and he removed anybody who called. He did admit he failed to return a call that he didn't recognize the number, and I don't believe a message was left. He apologized to that gentleman this morning and sincerely meant it. He was happy to take anyone off who contacted him, and he had no problem with anyone who contacted Mr. Richter to be taken off. It was his understanding that's how the process was supposed to happen. In summary, Mr. Hubey tried to file a complaint regarding a piece of mail that was in violation of the disclaimer requirement. He reasonably relied on the guidance of the Elections Commission on how to go about filing that complaint. He made a good faith effort to file a valid complaint, and it should be not found to be frivolous.
Thank you, Ms. Swanholm. Questions of Ms. Swanholm by the commission? Thank you.
Are you going to call a witness as part of this?
Only if there's specific questions.
Okay. I have a couple of different questions.
Okay.
The first question is, in the standard disclaimer case, so item went out, no disclaimer on. Would you agree that the complainant would most likely file something against one, maybe two individuals, meaning a particular candidate or a treasurer? And the analogy that I'm making here is, why did 30 or 40 or whatever the number of people, even if he was looking to the Facebook group,
right?
Why was it necessary to file against so many people, if he felt that Mr. Bainbridge was the leader of the organization.
I think Mr. Bainbridge was just the title plaintiff because he was probably first alphabetical.
No, I'm not.
Okay.
Fine, but,
Okay,
you know, in this particular hearing where we're speaking about the egregiousness, the harm, and purpose nature.
right.
I think there is some bearing as to how many, the whole list of people and the different people who were situated,
Right.
et cetera, were part of this complaint.
I understand the question. I think the answer to that is the Facebook group had discussion about forming an action committee. Okay, they're not calling it a political action committee, but they're getting pretty close. Money's getting spent on signs, that's clear. And honestly, but for calling Mr. Richter and saying, okay, I've got this complaint, I've got this mail piece with no disclaimer. I've got a group of Facebook people who I think are probably responsible for it. And here's why, because this is the kind of discussion going on in that group. And he's told, put everybody on who you think it might be responsible. And was under the impression, understanding that those people would simply be contacted and could be say yay or nay, not part of it. I mean, I saw the responses that Mr. Richter sent me, certainly letters. Not everybody's included in there who you said had notified you. I don't know if those other people just called and told you. If that was the case, it certainly wasn't under oath. But no matter. Mr. Hubei took it at good faith. He took it at good faith if somebody called him. He was under the impression this is how he was supposed to file those. I mean, we have problems and that stuff's out there with no disclaimer. And it's hard. So he didn't know what to do and called, and that's the direction he was given. Now,
But we have people that were removed still here today, again, indicating that they were, aggrieved. Essentially, the argument is, so once it was put out there, my good name was put out there, then I was harmed at that particular point. So the removal, that's nice, but the harm was already done, which goes to the, issue of should the series of names been on the complaint in the first place. Now, I cannot remember the type of law that Mr. Hudi practiced, but as a plaintiff's lawyer, many times in complaints, you put a series of John Does where John Does or Jane Does. Cause me trouble which one I choose. You put a series as placeholders until you would move into a different phase in order to really discover who was responsible or who should be a defendant in the matter.
right, I understand that. And all I can say is that he was trying to do this the right way. He thought he was doing this the right way.
I want to make a statement to respond.
Ms. Wellham, if he's going to respond, maybe we should.
Of course.
Please, for Mr. Dubay.
And I'll let her. Yes. So answering your specific question on why there were so many names on the complaint. When I sent the draft complaint to the OEC to review for procedure, I also sent the full list of everybody that it was going to be filed against. And there were, 30, 35 names, on the respondent list. And that was reviewed. If there was a point where somebody, where it would have been said, in these cases where this kind of thing is brought to your point, where like usually it's one or two people, that would have been the time to bring that. And I would have said, okay, like, let's rework this and like make sure that it's done in the proper way. But I wasn't told anything different, so I got an email back basically saying the information on this is sufficient. This is good to file, and I filed it. So, I mean.
Counselor, the complaint though is not Mr. Richter's complaint. It's your complaint. I'd be interested in knowing, again, just refresh from my memory, what efforts you made to identify the basis you had for including each of the 30 to 40 people on your complaint before you even sent it to Mr. Richter.
If you'd like, I mean, we can go through every single person on the complaint and say where they are in that package.
I'm not opposed to that, Counselor.
I'd be thrilled.
I love that.
I'm talking.
But,
Well, I mean, I think there's general categories here. There were people on the Facebook group. And he has other sources.
Such as.
Well, folks, please, all right,
Sorry.
we're gonna be respectful, and please be respectful of us.
Okay.
Okay, go ahead, Ms. Wall.
Okay, everyone here is well aware that Mr. Hubei is from Cleveland, not from here. He filed this on behalf of a client who wished to remain anonymous. He told Mr. Richter that when he called on December 20th. Thank you, December 8th in 2020, and said, this is the situation. And is this sufficient? He described it to him. Now, look, I've known Mr. Richter a long time, and I view him to be a very honest person. I think there's plenty of room here for misunderstandings, that Mr. Richter thinks he's saying one thing, and Mr. Hubei interprets it a different way and moves forward with it, and is under the impression he's doing completely the right thing.
Did he discuss with Mr. Richter, though, the basis for each one of the people that he included?
I don't think each one of the people, but he,
Or even as a class, Ms. Wilhelm?
I believe so, that as a class.
Could we ask some questions of your client about that?
Yes.
Okay. Mr. Hubei, you want to come back up
Right,
here, please? And I realize we had a hearing on June the 24th, and so I don't want to belabor the point, but my concern is that, we see 2, 3, 4, 5 people listed as respondents. Rarely do we see 30 or 40 people that are named. So what due diligence did you utilize to determine whether or not you had a viable cause of action against each one of the people that you listed in your complaint? What was your due diligence? What did you do before you prepared the complaint and before you sent it to Mr. Richter?
So the due diligence was, reviewing the communications that were in the Facebook group. And I think the central communication that, ties all this together is that a member of the Facebook group, Carrie Colombo, was defending the disclaimerless mail piece. And if she was doing that as a member of this group and as a leader of this group, which had described itself as an action committee, then why would she be defending it? Why would she be defending a mail piece that she had nothing to do with and these people had nothing to do with? Now, I'm sure there were people that joined the group because they believed their kids should be in school and they didn't know what it was. And if people, legitimately, if people were part of the group and had nothing to do with that piece of this, I am sorry that they were brought into this, legitimately.
But would you admit the damage is done once you include the name on the complaint? Whether they should have been on there or not, whether or not you extend an apology, isn't the damage done when a complaint is filed if somebody is named on the complaint? Particularly if they weren't involved in any way. I mean, you heard Ms. Helfrich testify, she was not even a member of the Facebook group. How did she end up?
How did I get it in?
Ma'am, please, with all due respect, how did she end up on there? What was the due diligence that you did with respect to Ms. Helfrich as an example that put her on that list? She said she's not even a member of the Facebook group. And then she was added on the amended complaint. What was your basis for that?
Chairman, if you don't mind, can I take a second and discuss this?
Of course, yeah. You need to take a break, Ms. Wilhelm.
Yeah, if we
Yeah,
could
we
just
could
have
take
like 5 minutes.
5 minutes?
Yeah, great,
5
thank
minutes
you.
it is. We'll take a break
Thank
for
you.
5 minutes.
All right. Yes, yeah.
Please do issue. Yes.
Yeah, we're straight through. We have the normal thing, maybe 15 minutes. Yeah, that's what I was thinking. Thank you. Yeah. Get to the issue. I'm just. I wonder, I haven't seen it. Number, so you're. I think once I was. I think once.
Yeah.
I second in those years. So. We were just talking about that. I mean, if you guys want me to have a statement.
That makes me really sorry.
It just depends. So that's all. I told them. I will speak to how to normally act in those kind of circumstances. You know, that maybe misunderstood. I'll apologize for any misunderstanding.
Yeah, that just because take something and run with it doesn't mean we can take that misinterpretation as perception. She's.
Yes. She was. No, I'm not talking about.
Oh,
No, I'm sorry.
Catherine.
Just talking.
Cool. Soon to be on it.
That'd be good.
Oh, Lord.
Students.
She might clear up. Wouldn't that be nice?
So. What that means is it's just let's get all. Or maybe using suggested that potentially here. Yeah, just some if there is. That's right. But it says no, it's also this action or useful terms. We haven't done that in the past. Statutes that reads, you know. The commission shall order the communicating cost of the commission. That is determined, so that's a determination. I guess we don't have. But it's not true. Something comes in us, it says. We're not committed to that. The committee does get the particular approach. I guess for that's the guidance. It's just already. It's the same thing. It's the reason that's not necessarily. Maybe that some people serve. Yeah, because I'm. Something salt. Shuts down, call clean up your stuff. Oh, good guys. Next meeting's small, maybe. Next meeting should be, well, next challenge. That means that you speak. Just so you know, people not coming back every 5 minutes. It's just on that. I yes, that wants some fun. I think part of this is. Turn kind of presence there. It's necessarily about one schools, that schools, because to disclose. What's on next? On 19th. 16th. The next. Yes. That will continue. Yes. 1, 2, 3, 4, 5, 6, 7.
These are just gonna take a while. 15 minutes flights. So. Oh, and then there's also Tiger's like an advisory. No, that's on this one. This is on transition. The job still saying.
Back on the record. As well, no?
One moment.
No, take your time.
Okay, thank you. So we have the categories of people. And the Facebook group, we've already explained how that came about. There were additional members, and that came about because Mr. Hubay got information from a city council person who provided some text evidence. So that's how they became on the list. He has the text here today. Can share those if that's helpful. He did not pull these people out of whole cloth.
All right. Is your client prepared to testify then?
Yes.
Okay.
Oh, yes. Commissioner Beatty, it is the practice of the commission not to accept John Doe complaint. That's my understanding. You want to say that?
I'll come up.
Go ahead, sir.
So so I got a phone call from the city council person,
Which the council person?
Michaela Honduras.
I'm not from Upper Arlington, sir. Who is it?
Her name is Misha Ayla Honduras. She's on Upper Arlington City Council on April 28th. And
She's on city council in Upper Arlington?
Yeah.
All right, go ahead, sir.
And she called me and she said, first of all, the people that were on the initial complaint were on the right track. And, you know, kind of backed up the work that had been done there, and, which I felt good about. And then said, you're missing some people though. Like, we've been getting correspondence from, additional people about this issue. And, there should be people that are added to the complaint, because if the OEC is trying to figure out who is behind this, you want to make sure that you ask everybody and give them an opportunity to respond either, yes or no. And, which was my understanding of what was happening. So.
Excuse me, when you say the issue, are you speaking of the bathroom issue or the 5-day issue?
Who was behind the disclaimer list mail piece, and who was organizing behind it, who paid for it and worked together to put it out. And she gave me more information. She texted me some information showing me like images of, information that had been sent to her. So what I did was I called the commission and I said, number one, we have a few additional names we want to add. Number two, I had people reach out to me saying that they had nothing to do with it. And I want to withdraw them from the complaint good faith because they reached out to me.
How did they end up on the complaint in the first place?
They were in Facebook group. The initial.
That's it. It's kind of a shotgun approach then to the practice.
I wouldn't call it a shotgun approach to the practice. They were part of a
What would you call it, sir?
They were part of a Facebook group that was calling it an organized action committee that defended a disclaimer list mail, the legality of a disclaimer list mail piece. And I think it was definitely reasonable to ask them the question, did they have something to do with it? And if they didn't have anything to do with it, they just say no, and that's that.
Did you reach out to any of these people that you included in your first complaint, but to ask whether or not they were involved?
No, but is that the responsibility of complaints with commission is to file a complaint with the commission. The commission reaches out to people, right?
Well,
again.
Go ahead.
He was under the impression, understanding from his conversation with Mr. Richter, that he should include names of who he believed were behind this. He believed that this group was doing this. Right or wrong, clearly this was not the intention to have this happen, but that's how he thought he was supposed to handle it, and did not realize, again, right or wrong, that it would lead to this. He was under the impression that it was a simple exercise of, okay, these people aren't on here. Okay, they've notified us. Okay, take them off.
And I'll totally admit, there's wires that got crossed here. Like my conversations with the elections commission, my calls to make sure that this is being done right. That if there was, I may have misinterpreted instructions, and if that happened, I'm truly sorry about that. And if people are involved in the complaint that had nothing to do with this, I'm sorry that they were on a complaint. But, the point of this was to defend Ohio's disclaimer laws. We had a reasonable, reason to do this.
Could you protected Ohio's disclaimers law by listing one person or two persons? What did you want the publicity, the political effect of 30 or 40 people by naming that?
Well, it's because
how did you arrive at that number? Why didn't you just go with one or two names that you were pretty certain, based upon your due diligence, that were included or that were involved, and just leave with that as opposed to 30 names or 40 names?
Yeah, and in that same vein, Mr. Bainbridge, why was he first?
Alphabetical order. Well, you spoke. Well, he also was the main organizer of the group. So actually, you're right about that. There were some A's, but he was the organizer of the group. He was the one that put the meeting together.
And Chairman Kreitz, to answer your question
Yes,
about why did he include all these people? I hate to keep harping on this, but he thought he was doing the right thing. His interpretation of what Mr. Richter told him to do was to include everybody that he believed could be a part of this. And then it's a simple exercise of yay or nay. Clearly that's not how it turned out, but he was following what he thought were the directions from the source of trying to do this correctly.
And Commissioner Beatty, to your point of why, and yours as well, like why there wasn't one or two people on it. Like, I sent the full list of respondents with who was going to be, there was a draft complaint to the commission. That would have been the point to tell me this isn't something that we've ever seen before, and this isn't the way it should be filed. There should be 1 or 2 people here on here and not 30. And I would have done that. I wouldn't have just filed it anyways.
Let me ask you this then. In the filing of the complaint, what was the result that your client wanted? What was the result? And I guess where I'm going next is, could that result been achieved if only 1 or 2 people were on the complaint?
The result was people should know they need to put disclaimers on mail pieces. I didn't think anybody was gonna admit to it. You know, like why, you know, but the result is people should put disclaimers on mail pieces. But maybe.
And it goes back to the initial question that I asked Ms. Wilhelm was, if this were, I don't use the word standard case, and we wouldn't, I mean, obviously, you know, if somebody was running for office, they didn't have a disclaimer on there. Joe Brown for city council, that person's a treasurer, they may have a campaign committee, they may have people, they may have hundreds of people that supported them, give money, whatever, that are on some type of public list. And then that even that money paid for the disclaimer that went, paid for the piece of literature that went out. If a complaint was brought just against the treasurer and the city council candidate, the same result could be achieved.
Well, the problem, I mean, the problem here is that if they had organized as a political action committee, you know, and filed, because they were conducting activity, like selling yard signs, they were calling themselves an action committee that was organizing, and if they had filed a PAC, it would have been pretty obvious. You just send a complaint to the treasurer and be like, it seems like you were behind this and there wasn't a disclaimer on it, and that's exactly what would have happened. But because they didn't organize and there wasn't a treasurer to send notice to, there was no other option but to send it to the people that were part of the group.
But earlier, didn't you just mention that the reason that Mr. Bainbridge was first, because he was the perceived leader? Now, not, you know, getting into right, wrong measures or anything like that, but he was first because he was perceived a leader. And when you look at what was submitted as the evidence, the Facebook things, and you're talking about, you know, he came up with the place, the time to have the meeting, whatever else, you know, went into these other conversations, you know, an argument could be made that he's the perceived leader.
Oh, certainly, yeah. But what I would say to that, though, is if they had set up a political action committee, the way I think we all wish they would have.
It should have.
And should have. Then, you know, then it would have been filed against whoever the treasurer was of that political action committee, whether it was him or somebody else. But because that didn't happen, in order to investigate this, there was no other way to go about it.
I guess if I'm looking at it, I see your point in that they should have, you know, formed a committee or, you know. But if I'm looking at it, there are a lot of people that are named, but if I'm looking for, you know, evidence of wrongdoing or whatever, there are a couple people that have said things that probably would have piqued my interest. And it comes down to really 2 people that as I look through this, who I think may have been, you know, like I said, just piqued my interest, but then it goes on, there's no proof within any of it of who, other than someone saying, I have yard signs. There's no one that says, other than saying like, you know, they looked into the legality of the mailer. But I just feel like there are people that actually even said, you know, what, you can't do that, you know, so to have people
Well,
brought.
Sorry to interrupt, that person wasn't included in the complaint, the person that asked Carrie Colombo that question.
Okay, yeah, and so I mean, I guess it could have been whittled down to Commissioner Beatty's point of who really looks like there's culpability as opposed to who just has their name on a giant list of, you know, participants in a group.
If I could respond, I think that's a fair point, and that's what we keep coming back to. I would say hindsight's 20/20. Certainly would have approached it that way if he knew he was supposed to approach it that way. I mean, I hate to keep coming back to this, but he thought he was doing it the right way, did his due diligence, contacted the Elections Commission, gave the draft complaint. I mean, again, we all wish it hadn't turned out this way, but he thought he was filing this complaint correctly. And he went to the source to get the information as to how to file a complaint.
And further, you know, in situations like this moving forward, where you have a lot of people that are behind, you know, some kind of political communication, and we don't know who did it. More guidance on exactly how those complaints should be brought, because it's something that's gonna happen more, is helpful, you know? Because like, I know that the, you know, to your point, I know that the Elections Commission is interested in enforcing these cases and wants these cases to be brought the right way. And I want to be part of the group of people that bring these cases the right way. You asked, you didn't know what kind of law I practice. I practice election law. You know, so I want to make sure that this is done the right way. And that's the reason why I was hired to bring this complaint. It's also the reason why I reached out to the commission to make sure that it was done the right way. So, you know, I wish that this, you know, situation hadn't occurred, but if anything can come from it, I hope that, you know, clear instruction on how these cases are supposed to be brought so that we don't find ourselves in this kind of a situation ever again. I know I would appreciate, but certainly I think everybody else in this room would too.
Thank you.
Good. One of the things that really bothers me in this case, I'll be honest with you, sir, is the fact that if you were not a lawyer and you have these issues and these questions, I could understand it, okay? You're a licensed lawyer. I mean, you've gone to law school, taken the bar examination, you've obviously practiced a little bit of time. I mean, if nothing else, even if you're a sole practitioner, you can reach out to other attorneys and things of that nature if you've got a question about how to file a complaint. But for a lawyer to come before this commission and to basically say their defense is, well, I ran it by the executive director of the commission and he said it was okay, so I'm off the hook. I'm not buying that argument.
I don't think there's a person on the planet who would be more, who would have a better understanding of what to do in front of this commission than the person I asked. There's no other attorney that I would have trusted more than the person that I talked to about this than the person I asked about it.
Did you go through each one of those individuals that were named in the complaint with Mr. Richter? Did you demonstrate to Mr. Richter that you were including them in the complaint because it was on personal knowledge?
Mr. Chairman, on the initial call to Mr. Richter, he asked, how do I handle this situation? This is a novel situation. I haven't been in this situation. I'm trying to figure out how to go about it. And he said a group of Facebook people. So, I mean, that's what he asked.
Okay.
And no, didn't
So
go.
I take the answer then, Counselor, is that he did not.
He did not,
He did not.
because it was.
And that's not, and that's not Mr. Richter's responsibility when somebody comes to them and says, I'm thinking about filing a complaint. What's the process? What's the
Right.
procedure for it?
Right,
You don't go through and each of the people that are going to be identified and include,
right.
you know, whether or not you think they violated the law and why there's a basis for that. So my point is, what really was this conversation that you had with Mr. Richter? Obviously, to call Mr. Richter,
Mhm.
to find out what the format was,
Right.
maybe what a complaint looks like, things of that nature.
Well,
But I mean, there's a lot of other things that go into the preparation of a complaint. Counselor, you know this as well as I do. I've been a litigator for 40 years. You don't just file a complaint based upon a whim that you think somebody might be involved. You do due diligence. You find out what their connection to the case is and whether or not you have an ability to be able to prove beyond whatever the standard proof is, make your case. And I'm not seeing that in this case. I'm just seeing a shotgun approach. It's kind of like, I'm going to go to this website, I'm going to go to this Facebook page, and everybody that's on here, every Tom, Dick, and Harry that's on here, I'm going to list them on this complaint. And I find that appalling as a lawyer. I mean, because that's not the due diligence that we're supposed to do before we bring any kind of cause of action, whether it be in a civil action or a criminal action.
With all due respect.
Yes, ma'am.
Chairman.
Go ahead.
The commission historically operates not quite at the same standards as a state court. It just doesn't. Things, because you also often have pro se clients before you. I'm not saying he's pro se, he's not. But because of that, the standards are not always consistent. And the way to figure out how to go about filing something a novel idea, is to go to the source and ask, how do I do this? He gave a general description of a group of Facebook people. I mean, I think this literally boils down to two people communicating, one person hearing A, one person saying B, and it's passing. I mean, again, I went back and watched the meeting of June 24th. He doesn't appear ruffled. I mean, in that, oh my gosh, I did something wrong for the longest time because he thought he was doing exactly what he was told to do. I mean, again, clearly we all wish it hadn't turned out like this. Clearly, we wish people hadn't been harmed. That was never the intent, and that was not the impression of what he thought was going to happen. He thought that this would go out and it was a simpler process for people to say, I wasn't involved, take me off, done deal.
Thank you. That's right.
Thank you.
We hear that, we hear what you're saying, and that's all after the fact. He wishes it wouldn't have happened. I sat here and we sat through the June hearing. And I heard really compelling testimony this morning from the folks that were impacted by this. And Mr. Hubei, I know you heard it too. And I think you would agree it was compelling. This has an effect on their lives. And as I look at the fact that on June 24th, this commission dismissed the case, I wonder, we're here now to try to determine whether or not your actions were frivolous or not. And so my question to myself is, are we looking at a frivolous action as far as the complaint being filed? Or was the frivolous action including so many names on the complaint? I look at the definition of frivolous and it says not having any serious purpose or value. Was there serious purpose or value to include all those names?
Yes. And the reason why is if the mission of the commission is to find out who's behind a disclaimerless mail piece, you have to ask the people who might have been behind it. And unfortunately, because the group of people in the Facebook group didn't organize as a political action committee and file a 30D form with their board of elections, where they would establish a treasurer and a deputy treasurer who's supposed to get service for this kind of thing, then that's how it would have happened. But because they didn't do that, there was, there wasn't that was the way it had to happen. And further, there were many points before this was filed when this could have been brought to my attention as like, this isn't the kind of thing that, that should be filed and, be careful, cut names from this and, narrow it down, at which point that would have happened. But at no point before this was filed, and there were multiple conversations, like, was there a conversation about doing that? So, and had I been told, there's too many people on this complaint, I would have narrowed it. I wouldn't have just notarized it and filed it and said, I don't care. So, for any miscommunication that happened here, I'm truly sorry about that. But I was acting in good faith here, and it wasn't malicious. It wasn't to like drag anybody's name into the public. It was to enforce a disclaimer law so that the people that received that mail piece in Upper Arlington knew who sent it. Because there's a lot of aggrieved people on the other side of this too, that are receiving mail pieces and they don't know who it's from, saying don't vote for a levy and don't vote for these school board members, and they don't have any idea who sent it out. So I think, there's definitely, there's several sides to this.
All right.
Go ahead.
Go ahead.
I mean, it's, as you're speaking to the people on the other side that were aggrieved, has it come about? Has there been any evidence as to who the real perpetrators were?
The attempt of this exercise was to find out who the real perpetrators were and have them respond to the commission saying, either I had something to do with it or, as we all know, somebody acting alone. If it was just one person acting alone, which I don't believe because I think they formed a political action committee, could have said I paid for this myself and I wasn't working with anybody else. That would have been an answer. But that answer was never received by the commission or me. The whole point of the exercise was to find out who was behind it. It wasn't to drag anybody into the public.
But not everyone responded. And as I mentioned earlier, I don't know if everybody responded with a notarized letter. I mean, I wasn't provided that anyway. I was provided some notarized letters, but, somebody could call up and be Joe Schmo saying they're, you know, Joe Abba and say, I didn't have anything to do with this. You know, we don't have responses from everybody.
Any other questions of council?
I have a comment. And I think from, you know, my short tenure on the commission, typically when something is brought to us, we have, you know, we're not the fact finding to find out who did it. We are actually responding to, it happened, this is the person who did it or didn't do it, and then we decide from there. So to use this commission as the fact-finding commission, I think is not the point of what we do, or am I wrong? So to name that many people, and it's been said, and I truly believe you didn't mean harm, but to sit there and have people who, you know, clearly, you know, and it was even stated damage has been done. I think that that's something that that can't be taken lightly. You know, and I'm not an attorney, but my husband is. And so I've heard him say, well, you know, they were so upset about going to court or they didn't understand the process. Well, as an attorney, you do understand, you know, you understand. And so it's no big deal. But to the people who have never had any action brought against them, it's probably very, you know, disconcerting. And I think that that goes to the emotion we're hearing from Mr. Bainbridge and Mr. Johnson and some of the others as well. So I just think that, you know, that can't be discounted. So.
Thank you, Tasha. Any other questions by the commission? If not, I'm at the stage to cut off discussion amongst council and have a discussion amongst themselves. All right, thank you very much. Okay. Commissioners?
I would like to, we've heard for about 2 hours now, I think, we've heard the defense from Mr. Rubin, primarily that somehow Mr. Richter gave him advice. And then we heard from Mr. Rubin's counsel that maybe the wires got crossed somehow. I would like to hear from Mr. Richter as to his recollection of what transpired.
I will gladly speak to that. I view my role as, I don't know, something of a gatekeeper maybe in matters coming before the commission. When I have complaints presented to me, either in advance as this one was, which is a rare occurrence, but it has occurred in the past, or when an actual complaint is filed, and looking for basic elements of a complaint: name of complainant, name of respondent or respondents, written narrative that explains the facts and circumstances, proper notarization, a reference to original signature, and a reference to the Section 8 of the revised code. And that's what I'm looking for when a complaint is presented to me. And certainly, I'm not trying to deny that I had conversation with Mr. Hube going forward on this. If there was any misinterpretation of either my role or what I said, I will offer an apology for that. But I look at my role as, you know, just checking for those basic elements. And if they're there, then the matter will go before the commission. I can't tell someone whether to file a complaint or not. I can't tell them, I can tell them if the complaint is improper in some manner or form, if there's not an address, if there's no reference to a revised code section, something along those lines, then I'll reject it and send it back. But other than that, I've always viewed my role as just, again, being something of a gatekeeper, making sure things move along, they get presented to the commission, and that's it. When I looked at this complaint, as it was presented to me, I had talked with him in advance, and he said there was the circumstance when it was originally called. I had not seen the mail piece. I had no clue what the circumstances were. Eventually, I did see it. The complaint was submitted to me, and it contained those elements. It contained more names of respondents than I'd ever seen before. But I didn't know. I don't know where those names came from, how they were included, whether they should be included or not. I don't view that as my role. That's a matter of what the complaint can establish, what the complainant can establish, what the respondent says. And so when I looked at the materials that were presented to me, that's all I was really looking for and looking at. And, you know, again, sorry if there was a misinterpretation of my role or my, you know, how I acted in this circumstance, but that's what I do. Again, I can't tell someone whether to file a complaint or not. And admittedly, and I've said this before, these kinds of circumstances are some of the more challenging circumstances that the commission faces, just because of the way the statute reads. The statute allows an individual to not put a disclaimer on any material. And so when a piece of material like this is circulated, that's one of the first things I always have to, oftentimes I would say, have to express to someone is, you know, have they, if it's an individual, they don't have to put a disclaimer on there. Could it be, should it be a PAC? You know, possibly, maybe. But again, that's not something that I can know until all the facts of the case are presented to us between a complaint and a response. And after you get a response, sometimes you get somebody that says, yeah, we should have been, we should have filed as a PAC. We didn't do so. Other times you get situations like this where everybody kind of responds in and says, nope, I had nothing to do with it. It wasn't mine. And unfortunately, you don't necessarily find out who was truly responsible for a piece of political literature that circulated, because that's what the statute allows. And the independent expenditure statute is there. And it presumably, if someone's acting independently, they're not required to put, they can not put a disclaimer on their literature, but they may be obligated to file an independent expenditures report. But again, if they don't do that, you're kind of left in a lurch as well under that set of circumstances. So it can be a very challenging area for this commission to deal with, and for people when they end up calling me and asking questions about the circumstances. I've rambled on for a while, hopefully that helps.
No, it does help. Thank you. What's the pleasure of council, of the commission?
Are we allowed to speak?
No, sir, we're past that stage. We gave everybody an opportunity, but.
Well, they just presented certain things.
I understand, sir, but we're at a point now where we've cut off that, and the commission's going to have discussion amongst themselves, and then we're going to decide what, if any, action to take.
Okay, I just want a point of clarification on this.
No, of course. Thank you very much for raising that. So where's the commission on this right now? We have an opportunity to decide whether or not the conduct was frivolous or it was not frivolous. Those are the options that we apparently have at this point in time.
Yeah, correct. The statute gives us the opportunity to may or may not.
That's correct.
Find that it's frivolous. So
that's correct.
I guess we get back to, or I get back to, was he doing his due diligence by including all of these names, or was it an overreach? And it's not an easy question to answer. Again, we've heard the testimony today. We've heard the testimony back in June. We didn't think there was sufficient evidence in June to warrant this case going on, and so we dismissed it. Does that mean anything as far as this being a frivolous suit? And I don't think it does. I think those two stand alone. I do believe that Mr. Hube was not doing anything with an intent, and I understand the statute doesn't talk about intent, but I think it's something we have to take into consideration. Was there an intent to do something nefarious here? And I don't think there was. On the other hand, I never really got a satisfactory answer as far as why all those names had to be included. And frankly, the defense that somehow Mr. Richter had a part to play in this just doesn't bode well with me. I think any attorney that's bringing a complaint before this commission has to do his due diligence to make sure that complaint is proper. So having said all that, not sure what everyone else thinks.
Well, I do agree with Mr. Hude or Ms. Wilkham, I can't remember when it said it, that this could occur again and again. This particular, they call it novel circumstance. It could occur again. And with that being said, that the commission should put out some guidance. I use the word guidance, not deterrent, not necessarily punishment. However, a penalty that, or excuse me, the determination that this particular conduct is frivolous, that would be the guidance. And that would be out there.
See, I think we have the Ohio Revised Code section 2323.51 that very clearly spells out what is frivolous, and I think that needs to be the guidance that we follow. I mean, it's in the statute, you can take a look at it, there's 4 different ways that you can find the conduct to be frivolous. I think if we want to go ahead and synopsize that and put that in some sort of guidance that we send out, that's probably fine too. But the fact remains is that what is frivolous and what's not frivolous is very clearly laid out in the statute. And I don't want us to run afoul of that.
I agree. I know. I agree with that, but I agree with that as well. The statute, whatever. But when litigants are making a decision on a complaint, it's putting a set of facts and circumstances, what runs afoul of the statute or not. And so I guess what I'm saying is this set of circumstances, whether, and I don't know how I would phrase it here, where you need to put as many people as possible in the complaint, the whole universe of potential violators. If you don't know the exact person, okay, that set of facts and circumstances, is filing the complaint that way frivolous or not frivolous under the statute that you mentioned?
I agree with that, especially in the age of social media, where it would be easy to pull a list and screenshot it and submit it as those who are culpable, as opposed to, I mean, it certainly, there was a flyer that went out without, a mailer that went out without a disclaimer. That is absolutely, needs to be addressed, and, but if you can't find who did it, you can't just throw everybody that into the pot and stir it up until you find, hopefully find someone that will admit to it. That seems, if not frivolous, extensive to me. So, and I don't believe there was intent to harm people.
The important thing to understand, though, is that, you don't have to be malicious for the statute to be frivolous. Okay.
Right.
I don't know, Mr. Gouvet. I'm taking a look at the facts based upon the record as it's been developed on June the 24th and now today. And it appears to me, based upon the state of the record, that he has engaged in frivolous conduct. Does that mean he's a bad person? No, I'm not going there. That's not what it's all about. It's a question of whether or not he's engaged in frivolous conduct. And the fact that he's a lawyer, and I do hold him to a little bit of a higher standard than I would somebody that's pro se. So, I would favor, a motion that would find his conduct to be frivolous. And then we could move on from there, either today or some later date, to determine what, if any, sanctions there are to be. But that's kind of where I am, folks. Anybody else, or is there a motion to be made?
You waiting on me?
Yeah, kind of.
Yeah.
Okay, I move that the complainant's conduct be considered frivolous. That be the way under our revised code.
Section 2325.51.
2325.51. 5.1.
I would also ask to then include 35-17-155E, because that's the specific section for which the commission is responsible.
Okay,
Council.
all right. Do we have a second to that motion?
Second.
All right, we have a second. We have a motion that's been seconded that would go ahead and find the conduct that Mr. Hubei engaged in to be frivolous pursuant to Ohio Revised Code Section 2323.51 and is it
155E.
155E? Correct. Discussion on the motion. All in favor of the motion, signify by saying aye. Aye.
Aye.
Opposed, same sign. Motion carries by a vote of 4-0. All right, conduct has been found to be frivolous. The next step pursuant to the statute is for us to determine what, if any, sanctions are imposed. I'd suggest, in light of the fact that we still have a pretty heavy docket after this, that be set down as quickly as possible. We're going to want information from the executive director with respect to the costs that are associated with the hearing on the 24th, and any reasonable attorney's fees may be an issue as well. So I'll leave that up to you, Mr. Richter, but I suggest that we kind of defer that part of it until we have more information. Okay. Counselor, good. Ladies and gentlemen, thank you very much for your attendance. We appreciate it. Take care.
Is that happening now? Yes, I just texted Catherine. That we're in.
Okay. My phone says that we're 7 minutes late for lunch.
I just got.
Don't worry, the later we are, the more available.
They canceled the half hour.
Oh, okay. Scott said he canceled half hour.
Damage.
Mr. Paul, if you want to come on up and at least get ready, when the other two commission members are back, then we'll be prepared to go forward.
Scott made a phone call. Scott made a phone call.
Yeah, said he canceled already. Yeah.
Oh, he canceled it.
Are we comfortable with that?
For the reservation.
Yeah. We're just waiting for the other commissioners to
They serve
return.
lunch for you, huh? That's okay.
I was kidding. I don't care one way or another.
What's that?
Outside.
Otto did not bring snacks today.
And I have that 3 o'clock appointment up north with the point.
Tough luck.
I've got, no,
Tough luck.
on your review, I'll make some really wise ass comments.
We've already gone over how many times.
While we're waiting, I'm gonna introduce one exhibit. Do you mind? if
Yeah,
I just-
we're not on the record though, so I mean, if you
No,
want.
I just want to
Distribute
get them out.
them. Okay.
Yeah, I'm gonna distribute them. I only have 4 copies, so apologies for that.
No issue here with my stomach growling.
Are you getting hangry? I'm getting hangry.
Yeah, I noticed that. You were starting to get a little. I've been in practice. I'm early riser, but I had 2 meetings before. And it's like. Meeting tonight, so I'm. Thank you.
Did you bring snacks? No? All right.
Welcome back, commissioners.
Did you miss us?
You were, I was about to say, which right out, man, we missed.
I did not miss it.
Yeah, well, thank you, I appreciate
Oh,
that.
wow.
All right.
They've been having a
Please
good
put that on
time
the.
among.
All right. Back on the record. Next case is under a hearing category, case number 2021G-006, the Ohio Chiropractic Association et al. Mr. Ricker.
Mr. Chair, members of the commission, this matter was before the commission previously, when we set it for hearing. This is a self-referral that the current executive director of the Chiropractic Association filed with the commission. They are out of balance, essentially, in their campaign account. After discussions that they had with the staff people at the Secretary of State's office, in an effort to try and reconcile the matter. They were encouraged, they filed a referral, an effort to bring into compliance, so that they can continue to, so that they can proceed forward. The commission originally reviewed this preliminary review. I think you, Mr. Chair, more than anybody else, had some questions and concerns as it related to what the, what happened during the previous administration. And so the matter was set for hearing, which is where we are now. Mr. Strata was identified, Nicholas Strata was identified as a part of the materials originally submitted to the commission. I have subpoenaed him to attend. I believe he's here today. Mr. Pauly is here on behalf of the, Brandon Pauly is here on behalf of the Chiropractic Association. Ms. Spalding, Brandy Spalding, is the complainant, and she is the current executive director for the Chiropractic Association. So that's all we're here for is to essentially make a determination that we can declare them in compliance with statutes, identify what their current balance should be, so that they can then use that to go forward with subsequent campaign finance reports, because they plan to continue in existence. Okay. Ms. Pauly, are you ready?
Yes, Chairman, Director, Commissioners, thank you very much. My name is Brandon Pauly. I'm here on behalf of the Ohio State Chiropractic Association. With me on my right is the current Executive Director, Brandy Spalding. Here in the audience as well, per the subpoena issued by the Commission, is the previous Executive Director, Nicholas Strata. Mr. Rick's summation of the events as to how we got here, I don't need to reiterate those. You had a long enough day. What I hope to make the commission aware of is that in doing the self-referral and coming to the commission to seek, for lack of a better term, a clean slate going forward, the Ohio State Chiropractic Association has had this ongoing for the past 4 or 5 years, working with submission of reports, those, I'll call them correct, denying that. There have been attempts to reconstruct and reconcile the past reports. The reports that are subject are for 2016 through 2018. Those include the annual, semi-annual, and post and pre-election reports. Since 2019, the reports are reconciled from standing in compliance up to date. So May 5th of 2021, the Ohio State Chiropractic working all of reports for the 20 working compliance. Today, 2021, all of the reports are submitted, reconciled, and compliance. The issue is coming back 2 years, change of regime, so to speak, the OSCA. Unfortunately, there were just some record keeping issues. I'm at the point anybody, we're here to look forward. Hear her test. The OECD. Correct, accurate, and in compliance. What we are hoping for today, I'll just say slap on the wrist, do better. But on top of that, we would want the current balance on hand, which is $34,661.01.
What was that again, 34,000?
$34,661.01. And that is from our most recent report, the 2021 pre-general. We would request that that be deemed the current balance on hand. Forward. Apologize, I didn't have enough for everybody. I scattered four. Exhibit A, and it is our May 14th, 2021 self-disclosure. Within that self-disclosure, you will see 3 exhibits, I believe, are marked A, B, and C. And those markings lead to another point that I wanted to make about OSCA's attention to this matter. This is not a failure to file. This is merely under 3517.10, the disclosures of expenditures and oh, sorry, I forgot the word, but what it received, receipts and expenditures. And OSCA, even in the previous regime, they did attempt to work through these issues and attempted to reconcile. This wasn't an ostrich burying their head in the sand and ignoring the procedures for what they should be. This purely was a record-keeping issue that has since been reconciled from a go-forward perspective. So I do want to make that point for the commission as well, that as is demonstrated through the multiple communications, reports were filed, reconciled reports were filed, unfortunate record-keeping circumstances led those reports to have an inability to be completely reconciled. So with that, I'll take the commission's questions. And if the commission would like to hear from Dr. Spalding or from Mr. Strata, we would be happy to do that as well.
Thank you. Questions by the commission?
I heard you say that you just want a slap on the wrist. This was an accounting failure over a 3-year period, correct?
Yes, sir.
And is it my understanding that the discrepancy was over $15,000?
I thought it was slightly less. 15,000 is about right. I thought it was about 14,300, 13,400.
And how did we go about reconciling the fact that we couldn't account for almost $15,000 in funds?
Well, through in today, I believe there are identified certain items that they not have documented receipts of either a receipt or expenditure. You know, that brings up a very good point, Mr. Norman. One of the other points on my checklist here is that we also want to demonstrate there was no malfeasance relates to it. Proper expenditures. This wasn't somebody pocketing money. It's for expenditures that do not have sufficient background information to demonstrate.
Did they have a designated treasurer at the time?
They did, yes.
How could you, just following up on that, I know that you talked about that has been reconciled since 2019. But how could you reconcile in 2019 if you couldn't reconcile the 3 years prior? It wasn't about the balance of the money, or I don't understand how you could ever reconcile in 19 if you couldn't be in 18.
If you don't mind, Dr. Spalding, she can be sworn in.
Sure.
Sure, to be sworn. Would you swear, doctor?
You swear from a temperature? No, truth, nothing.
Would you mind coming
an update from his perspective about our ongoing issues. And he also let me know that we had not yet filed for 2019 and 2020, so that needed to take place. Representatives of the OSCA had met with the Secretary's office on these issues, and I know that there were some attempts to reconcile some of the discrepancies, which when one report had changes to it, there was a trickle-down effect that affected the other ones. And so, yes, there were some, that balance was brought into a closer proximity, but it remained and it affected multiple reports because of that. And because recommended action had not been taken, and because we had outstanding reports, he said, what I would recommend you do is move forward with the self-referral process. But in order to do that, you first have to file your 2019 reports. And you need to figure out what you're in 2019 in that account, and use that as point going forward, so that when you make your self-referral, you can do it with a number that is consistent with what your contributions and expenditures were from 2019, 2020 to current, and how I proceeded. And then I reached out to OSCA legal counsel, let them know what it was, and for getting the self-referral. Yeah. So, I mean, I did find some issues, related to how we were tracking things and reporting things. So, for example, perhaps a contribution which went into a management system, association system, a contribution, but that maybe went into the bank during that period, or even during that month, maybe went a month or two, or which 19. Going back several years when you were involved and you have copies of all of those transactions and trying to get copies of those transactions so you can find out where did this check go? Why don't I see it here? Why do I see one here, but I don't see an internal transaction for it, and matching up all of those pieces. And so that seemed to me to be the primary piece. And if those reports weren't happening timely, and or maybe the person that was doing them didn't have a full understanding of it, if they were entering certainly the account
placed in your corporate account and not in the PAC.
No, I'm not saying that. Although I did find an example of that happen and fixed it. But when we record the transaction in our internal system, or part of my process when I reconcile this, is all of our transactions are recorded in our management software. And so I take that report of what has happened and run that against, of course, our merchant processors and all of the copies of the checks and so forth, and then compare that with our bank statements. And all of that information gets into the online portal for reporting, and all three of those reports should match up. And if it doesn't, then I'm missing something somewhere. And so I just don't think that that's which could have incorrectly to be.
So did you ever reconcile the 14,000, 15,000, whatever it was, dollar discrepancy? Did you ever figure out what you're saying? It's a lack of reporting. And then frankly, that's what you're doing, because we're like, how did that happen? And did they ever find that money or figure out what happened? Because it sounds like, let me back up this, but I do want to know that, but what was the difference between the number that was in your bank account in 2019 when you began accurately and
fund that's 500 versus 15,000.
That's the thing.
That was where we ended. Yeah, I would have to double check that, unless somebody you recall. Okay, I certainly we have that information available because I did determine what our starting point was for January 1st of 2019.
Sure.
And we did have a report filed, our last report in 2018. Of course, we could compare, take a look at those, but I.
Can you access that, Bill?
Yeah, Bill should be able to get that.
So you're looking at you're looking at the 2000 annual then, is that, or?
Where we ended 2018 from a report perspective versus where we started our January.
Yeah, I kind of look through because they don't necessarily have them all in order.
Do you know where you started 2019?
Yes. No, she didn't.
I did.
What the latest.
Yeah, you said.
Yeah.
That's what your current balance is.
Yeah.
Exactly.
And I can tell you that, I mean, when this report was filed, or when the self-referral was in May this year, which would have been of 2020, being balance in the, oh no, it's right here. The balance of the CPAC reports for January 1st, 2019, 70,046.
17,000.
546.
That's. 2019.
That for 2019. The he's going